Mr. Lies.
Mr. Chief Justice, and may it please the Court. Over the past 50 years, this Court has had opportunity to review many campaign finance laws, and it has appropriately treated many of them skeptically. But it has never wavered on one foundational pillar. Congress may limit contributions to candidates. And while the current system imposes strict limits on nearly everyone else, my clients and the NRSC and the NRCC are given a special privilege to make millions of dollars of in-kind contributions to candidates. These limits on in-kind contributions are called coordinated expenditures, but they do not pose any meaningful burden on party speech. In fact, the vast majority of them hardly involve speech at all. The practical effect of Petitioner's case would be to convert the political parties into mere paymasters to settle invoices from campaign vendors. This Court has repeatedly recognized that these are just contributions which provide only a general expression of support for candidates. Congress may regulate them. I welcome your questions.
So if you say it's not speech at all, can it be totally regulated? Are there no limits?
Under the Buckley framework, there are still limits on regulation of contributions. This Court's decision, for example, in the Vermont limits case, said that limits could be so low.
No, I mean, you just said that there is no speech component to this, that they can be regulated. So what's the protection if there's no speech component to it?
So there is a speech component. What this Court said in Buckley is that the speech component is in showing support. In other words, is in making a contribution is an act of speech. And in the Sorrell case, this Court said that there was a limit to how low party limits could be, that you would effectively deprive that of being able to make that speech component. My point, Justice Thomas, is that I think imagined in the ether is the sense that what's going on is that the Republican Party wants to create an ad on their platform. And they lament if only they could coordinate with a candidate, they would make this ad on their platform more effective. That would be an interesting as-applied challenge. That isn't either their facial challenge, nor reality, nor even their as-applied challenge. What the NRSC and the NRCC wish to do is to simply pay the bills of campaigns. Bills that may not involve speech at all, may involve, for example, flowers, or may involve hotel blocks, and in which the party may not even know that the bill was incurred until they receive the invoice and are told to dutifully pay it. And that poses a very different profile of the kind of speech interest that is at stake here.